going to begin by introducing ourselves. My name is Allison Ide, and I'm from the Colorado Supreme Court.
My name is Melissa Hart. I'm a professor at the University of Colorado Law School.
And my name is Bobby Pace. I'm a professor at the Community College of Aurora.
And could you introduce yourselves and your coach?
I'm Amy Troutman, and my coach is Judge Troutman.
I'm Quan Nguyen, and my coach is Judge Talman as well.
I'm Sophie Creo, and our coach is Judge Talman and also Jeff Brandon, our teacher.
Thank you. We are going to begin. We are, of course, our Unit 3, and we are asking question 2. How has the Constitution been changed to further the ideals contained in the Declaration of Independence? How does the right to due process of law protect an individual's right to life, liberty, and property? How would you distinguish between procedural and substantive due process? And how is due process related to natural rights philosophy and the principle of limited government? Please begin.
James Madison wrote, "The essence of government is power, and power, lodged as it must be in human hands, will ever be liable to abuse. To maintain checks on power so it is not abused, due process, as stated in the 5th and 14th Amendments, limits the federal and state governments by protecting the citizens' rights to life, liberty, and property." Two types of due process, substantive and procedural, separately restrict government power. However, they do so in vastly different ways.
Substantive due process requires the government to honor each person's fundamental rights to life, liberty, and property, derived from John Locke's natural rights philosophy. In Loving v. Virginia, the Supreme Court held that a state law preventing interracial marriage was unconstitutional since marriage, as Chief Justice Warren proclaimed, is one of the basic civil rights of man, fundamental to his very existence and survival.
Additionally, in Lawrence v. Texas, the Supreme Court declared anti-sodomy laws unconstitutional and ruled that individuals have the due process right to choose their sexual partners of either gender, thus protecting the fundamental right to liberty. And the Supreme Court case Roe v. Wade recognized the inalienable liberty protected by the Due Process Clause of a pregnant female to control her own body. Although these rights to marriage, choice of sexual partners, and abortion decisions are not specifically protected in the Constitution, they are still fundamental to the basic notion of life and liberty, and are thus protected by due process.
Substantive due process also protects the natural right to property. In BMW v. Gore, the Supreme Court overturned a verdict awarding Gore compensatory damages and punitive damages, because the punitive damages were not proportional to the compensatory damages, and thus violated BMW's natural right to property.
While many Americans cheer the use of due process in these ways, it is not defined in the Constitution. Therefore, courts hold vast power to interpret the meaning of due process differently over time. For example, early last century, the Supreme Court used substantive due process to declare minimum wage laws unconstitutional in Adkins v. Children's Hospital, ruling that individuals have the freedom to contract however they choose. Today, courts apply substantive due process in different ways.
While substantive due process protects fundamental rights, procedural due process requires the government to provide notice and hearing before depriving an individual of his or her natural rights. This prohibits the government from acting arbitrarily while enforcing its laws. The basic protections set forth in the 4th, 5th, 6th, and 8th Amendments, such as protection from searches or seizures without warrants, protection from self-incrimination, an impartial jury, and protection from cruel and unusual punishment, as applied to the states via the incorporation doctrine, limit the government because it must provide individuals notice of their rights and give an opportunity to be heard at each step of a criminal case.
For example, in Miranda v. Arizona, the court ruled that Miranda had to be retried because he was not advised of his rights before his interrogation. And in Batson v. Kentucky, where the prosecutor used his peremptory challenge to create an all-white jury, the court ruled that the right to trial by jury was such a fundamental feature of the American system of justice that it was protected against state action by the Due Process Clause of the 14th Amendment.
Due process rights extend to civil cases as well. In Goss v. Lopez, where the defendant was suspended from school, the Supreme Court held that Lopez's procedural due process right to a hearing was violated since he was not given the opportunity to appeal his suspension to the Board of Education. In civil as well as criminal cases, the procedural due process rights to notice and hearing require the government to respect Americans' constitutional rights in all proceedings. We are now ready for your questions.
Thank you. Well, we have a few follow-up questions. I wanted to start by asking you, excuse me, how's the concept of substantive due process related to fundamental rights? Are they the same? Are they different? What's the relationship?
Substantive due process protects the natural rights to life, liberty, and property, and so the court can interpret this in different ways. One example of right to liberty would be, as we stated in our opening statement, the right of a woman to have control of her own body.
Okay, so what rights, if any, do you think should be identified as fundamental, and why?
The Supreme Court has the power to interpret what rights are fundamental, and I believe that one of the important rights that should be protected is the right to trial by jury. And in Duncan v. Louisiana, the Supreme Court held that the right to trial by jury was fundamental, and it was protected by the Fifth Amendment and by the Sixth Amendment, and applied to the states as well.
I also think the Sixth Amendment right to counsel, which is incorporated to the states, is fundamental. That was protected in the Supreme Court case, a criminal case, Gideon v. Wainwright, and also a capital case, Powell v. Alabama. And so I think that right is important as well.
I think another fundamental right would be right to a speedy trial. In Cloper v. North Carolina, Cloper decided to wait a couple of months until he had his trial, and the court ruled that the right to a speedy trial was in fact fundamental. And in another case, Quesada v. Mink, they arrested Quesada and held him in jail because they felt he was an illegal immigrant, although they didn't have the right to do so because he has a right to a hearing, and they kept him in 47 days longer than they should have.
Can I ask a follow-up question to Sophie? Actually, you mentioned Gideon against Wainwright and the right to counsel in criminal cases. Do you think that there is a fundamental right to counsel in some civil cases?
I think so. I think it's definitely important to be able to consult with an attorney, someone who's familiar with the justice system. And I don't know of any cases where that has been incorporated, but I think that is something that is important and should be protected by the Constitution.
So I want to flip to the other side of when we think about the relationship between the government and citizens and fundamental rights. We know that there are times when the government can regulate and limit the rights that we define as fundamental. And that's when there's a compelling state interest for doing so. How do you define a compelling state interest?
Well, I can't remember the case currently, but there was a child who is not a registered citizen, and he was trying to get an education in Texas, and the state didn't allow it at first because they said that it would impact taxes, and there's this compelling state interest saying that it would alter the economy because he was going to school for free and not paying taxes. But the court ruled that the compelling state interest was not enough because it wouldn't really affect the economy that much, and every child has the right to an education.
So that was Plyler against Doe, right?
Yeah.
So in answering that, you talked a little bit about one thing that could be a compelling state interest, that would be tax revenue. What other kinds of things, what should we be looking at when we think about how to define compelling state interests?
In Palco v. Connecticut, the Supreme Court held that the right to protection from double jeopardy was not incorporated, and doing so, Justice Cardozo established a fundamental rights test that was based on whether or not a right was a principle of justice deeply rooted in the traditions and conscience of the people. And although the ruling that the protection from double jeopardy is not incorporated to the states was changed later, the test still remains relatively the same.
Right, I'm going to push on you. That's the fundamental rights test, but what about compelling state interest? How do we decide? And I'm going to give you an example. In the Grutter case, which is about affirmative action, Justice Thomas wrote a really passionate dissent in which he said this identified compelling state interest of diversity in higher education really was not a compelling state interest. That the rest of the majority was making it up. How would you decide if the state has a compelling interest in, say, diversity in higher education or tax revenue?
I would say the state has a compelling state interest if the majority or the public is being hurt in some way. So if the tax revenue was in fact affecting the public in a negative way, or diversity in education was affecting them in a negative way, in the majority, then there would be a compelling state interest.
I agree with that because the government's job is to act for the common good, the public, for the safety of the public, just like Amy said. So as long as the government deems that what they're doing is for the common good, then it should be compelling.
Well, I think we're almost time's up, so I'm going to declare time. Well done.